Hello, everybody. This is Steve Yoder. Welcome to Week 6 in Legal Studies 457-557 here in the spring of 2023 at the UAB Collat School of Business. We are covering a great deal of legal territory here. As you can see here, 3 topics: agency law, which, as we'll see in a moment, applies directly to the next 2 topics: employment laws generally, and a subset of employment laws called employment discrimination laws. Well, let's go ahead and get started. Here is the answer to last week's extra credit question. President Biden wanted to raise the corporate tax rate from 21% to 28%, but he was not successful in doing that. It remains at 21%, but he keeps introducing an increase in the corporate tax rate in his budgets, as several of you correctly pointed out to me. In a separate announcement, I will provide some results for the class on the second exam that closed on Sunday night, April 16. We will start with our look at agency in Chapter 27. This is the most common and important legal relationship that there is. It has great application in employment law because the people who go to work every day are either employees or independent contractors, and which of those 2 things they are can make a great deal of difference in what their rights and obligations are. FedEx has consistently taken the position that their workers are independent contractors, and UPS says that they are all employees. 2 companies have their workers do pretty much the same thing, and we will go over that in the PowerPoint slides. This issue of whether someone is an independent contractor or an employee has gotten a great deal of attention in California, where, as you can see here in the green box, they have gone back and forth as to whether Uber and Lyft drivers and other gig workers are or are not independent contractors, and right now that is very much up in the air. It's going to the California Supreme Court. The history of employment laws in the United States is very interesting. Many people think that it really got started with a terrible fire in a clothing factory in downtown New York City over 100 years ago. Please take a look at the very short video that is in the learning module. The general approach that we supposedly take in the United States, although it doesn't seem that way in most cases, is that we can all be dismissed at any time for any reason, as long as it is not an illegal reason. The first laws that were put in place about 100 years ago after that terrible fire were wage and hour laws that control things like overtime. Here's a case in your textbook on that topic. The Obama administration worked very hard to get more people to earn overtime, but the Trump administration cut back on that. And today, there are academic studies that show that in order to get around paying overtime, there are a very large number of companies that pay their workers salaries just above the cutoff level, below which overtime is required and above which overtime pay is not required. Can you just ask your employees to waive their right to overtime pay? Take a look at the video in the learning module for that. Wages, minimum wages, very much a topic of legislation. Here you can see a map of the United States where there were increases that were going to go in effect in the minimum wage in 2023. One of the purposes of the original Fair Labor Standards Act was to guard against child labor, but recently that has been very much in the news. Here's an example of McDonald's getting fined for using child labor. And by the way, these companies are feeling the need for child labor because they can't find enough adult labor. Here's a state that very recently made it easier to employ children under 18 or people under 18. I don't want to characterize all people under 18 as children. And here's an example that has gotten some attention. You might have heard about it. Big factories, meat factories in the upper Midwest, for example, employing child labor, and some senators questioning that. The Family Medical Leave Act actually came across or went into effect much later than the child labor and the wage and hour laws, but today many people take for granted that they will get 12 weeks of unpaid leave to care for a family member or themselves. Income security laws are designed to make sure that at all phases of our lives we have income, whether it's after we retire, our survivors, if we die, if we become disabled, if we are hospitalized, that we can pay our medical bills. That is guaranteed really only for those 65 or older, or if we become unemployed. Here is where the distinction between an independent contractor and an employee becomes important, because if you are an independent contractor, you have to pay the entire Social Security tax, which is nearly 13% of your wages. Immigration law is very, very unsettled. Efforts have been made for 20, 30 years to try to make sense out of the system. The laws we have now were put into place 40, 50, 60 years ago and don't fit the modern reality, but all of us see the immigration laws. Whenever we take a new job, we have to e-verify, electronically verify that we may work legally in this country. Labor law, again, has seen a resurgence, perhaps because of the shift in supply and demand. Fewer workers means they have more power. We will all learn what the words right to work mean. Michigan is the state that just actually repealed a right to work law, and that I think is the wave of the future. The process of forming a union is very heavily regulated, as we all saw in two separate unionization votes that failed right here in Alabama at Amazon's Bessemer warehouse. This was not what happened at the Bessemer warehouse of Amazon, but this is what a finding was at the National Labor Relations Board, the federal agency that oversees labor law. This is what that agency found Starbucks was doing when the baristas at a particular store were trying to unionize. So stop, pause, look at those bullets, and you tell me whether that seems fair or not. Right? And the technical term is unfair labor practice. Moving on to employment discrimination, we will be looking at the very important protection provided by Title VII of the Civil Rights Act of 1964. Here are the protected classes we will be looking at. They include color or race. They are not the same thing. Religion, gender, and there are types of gender discrimination, both differential treatment and sexual harassment. Remember that we have been looking at non-compete agreements. There are many people, and actually some research that proves the belief of many people that non-competes are especially hard on women. We're going to be looking at sexual harassment, both some clear examples of what is illegal sexual harassment, and some myths. Some people think that certain things are not going to get them in trouble legally, and they are wrong. These are myths. Stop and look at those. Those are in the PowerPoint slides as well. We are also protected against discrimination based on our age. Here's an example of that in the textbook. And yet another law protects us against discrimination based on disability. Therefore, the definition of the word disability is very, very important. And then finally, we're going to be looking at the concept of affirmative action, sometimes called reverse discrimination. In 1978, the Supreme Court found that discriminating in favor of blacks and against whites to correct centuries of discrimination against blacks was illegal. But the Supreme Court found a way at that time, 1978, to uphold college admissions based on race. And recently, the Supreme Court has heard that very issue again. And here's your extra credit opportunity for 2 points added to your, this should be third exam. Tell me which 2 universities' admissions policies were before the Supreme Court for argument on October 31st, 2022, not too long ago. Here is our calendar. Today is Monday the 17th. We have lots due next week. Less than 2 weeks for the reflective memo by students in the Section 557 part of the course, a very short quiz on professional responsibility due on the 25th. The third exam opens on Wednesday the 26th, the same day that the final set of CPA client simulations are due. And then everything else, including the last exam, the third exam, due on Friday night, April 28 at 11:59 p.m.